Good evening. Hope you can hear me all right. I'm John Bryan, West Virginia civil rights lawyer. The civilrightslawyer.com is the website. And this is probably a long overdue video, live video anyways. I appreciate you joining me. I hope the audio is all right. Please let me know if it's not. What prompted me to have a video tonight is if you've been following the infamous AR-15 open carry case out of Putnam County, West Virginia, the Walker versus Donahoe case, we received a ruling from the Fourth Circuit today. And by the way, I'm at my Lewisburg office today, so it looks a little bit different, but fortunately my internet seems to be much better here, so hopefully it's holding up. But let me just give you a brief quote from the opinion that came down today from the Fourth Circuit. Again, this is referring to the case of Michael Walker, who was openly legally carrying in West Virginia an AR-15 slung over his shoulder on his way to go coyote hunting with his friend. And he got stopped and harassed by Officer Friendly with the Putnam County Sheriff's Department. So this is, to make a long story short, out of all the litigation, here is a nice little excerpt we got from only one court down from the U.S. Supreme Court. First, as heretofore explained, it is proper to consider the type of firearm that Walker was carrying, an AR-15 style assault rifle. As Corporal Donahoe, that's Officer Friendly, emphasizes, such rifles have been the, quote, weapon of choice for the deadliest mass shooters of the past decade. See the appellee's brief at 27 to 28, explaining that AR-15 style rifles give the wielder the capability to kill more people in a shorter amount of time than more commonplace firearms, making it an appealing choice for a would-be mass shooter and a greater danger to public safety than would more commonplace, less powerful, lower capacity firearms such as shotguns or handguns. Donahoe points to the massacres since 2012 at a movie theater in Aurora, Colorado, at Sandy Hook Elementary School in Newtown, Connecticut, at a holiday party in San Bernardino, California, at the Pulse nightclub in Orlando, Florida, at a music festival in Las Vegas, Nevada, at a church in Sutherland Springs, Texas, and at Marjorie Stoneman Douglas High School in Parkland, Florida. So the opinion that we got today out of this open carry case really wasn't all that unexpected if you watch the oral arguments, but it was basically a diatribe against the AR-15. It really is just an awful opinion. Now, this arises out of West Virginia, where AR-15 ownership is high, where AR-15s are legal to own and to openly carry. If you want to walk down the side of the road and take your AR-15 coyote hunting or not coyote hunting, it's absolutely legal to do, assuming you're not a prohibited person from possessing a firearm. But what we have here is West Virginia's first so-called sanctuary county, Putnam County, West Virginia, harassing this citizen who's not breaking any laws. And now we have court after court justifying it because AR-15s are bad, because freedom is scary, right? So I'll go through some of this opinion and what you need to know. If you haven't seen the video, I think I can play a portion of it right here. So there was a Karen call. Somebody had called 911 saying there's a guy with a gun that's walking down the side of the road. No other information. 2 Putnam County deputies arrive. That's my client, Michael. He starts to film what he knows is about to happen.
Huh? Not to buddies. Huh?
Got some ID on you?
Have I broken any laws?
I'm asking you if you got any ID.
Have I broken any laws?
I'm asking you one time only, if you got any ID.
Yes.
Can I have it, please?
Can you tell me what crime I've committed?
Because I'm asking you for ID. I have the right, absolute right, to ask anybody who they are and if they have any ID.
Unless
You do not have to break the laws for me to ask you who you are. Right or wrong?
wrong. Unless I have committed a crime.
No, sir.
Yes, sir.
No, sir. You want to do this or not?
Sir, I'm just trying to get to my
We're not-
destination.
Listen to me. Where's your destination?
You don't need to know that.
Well, you need to give me some ID.
What's your name?
Donna.
What's yours?
Paula.
Ollie.
So you can see here in the original video that I had uploaded, I cited United States versus Black, which is a Fourth Circuit opinion, over and over again because it really was directly on point to what happened here. This officer is saying that you have to give him your ID if he wants your ID. And Michael is saying, well, what did I do wrong? You know, West Virginia is not a stop and ID state. What crime have I committed?
Is that against the law?
Everybody in the world is going to call. You know as well as
I have been walking up and down this road for years, carrying a firearm. I have done nothing wrong. I am just simply walking up the road.
You understand it's everybody's right to see that carry a gun. I understand. Okay?
Then why am I getting stopped?
Huh?
Then why am I getting stopped?
Again, I can stop and talk to anybody that I want to, right?
Unless I have committed a
I'm
crime.
not patting you down.
I can stop and talk to anybody I want to. That's true.
At this point, I'm talking to you.
But he can't stop and perform an investigative detention of anybody he wants to, not without reasonable suspicion.
At this point, you can be on your way when I tell you you can walk on.
So he makes it clear now that he can't
At
leave.
this point, I have the absolute right to see whether you're legal to carry that gun or not.
Am I
Listen to
expected
me.
of not being
Listen to
legal
me.
to carry a
Listen to me.
firearm?
Listen to me. Have you ever committed any crime that would keep you from carrying a firearm?
No.
Okay.
But do you have the suspicion that I have committed a crime to keep me from having a firearm?
Everybody in the world. I have no idea. Everybody I come across. Yes.
So what we have here is literally somebody who was committing no criminal violation, who was doing something that was completely legal to do, walking down the side of the road where he was allowed to be, carrying what he was allowed to carry, and there were no indications that any crime had been committed
So if you have not,
at all.
you're kicked down the road, you can go do whatever you want to do, okay? As for taking that in any store, if you plan on going to any store, I would highly advise.
And this officer thinks that he has the right to stop and ID anyone he sees carrying a gun so that he can run their background and see if they're a prohibited person. It turns out that's not the law. So there's some legal gymnastics that go on with the defense lawyers and with the judiciary after the fact to try to make this out to be a legal stop, which it's not.
I don't have questions.
You got a cold?
I don't answer questions. Don't touch me or my property.
I'm just seeing what.
Don't touch me or my property.
You know what? I understand the whole sovereign citizen bullshit.
He's not a sovereign
And I
citizen.
have it up to here with this. I don't have to answer any fucking questions or whatnot. You make it more fucking difficult for anybody to do the damn job out here. I'm just wondering what you have. I'm not going to take it from you at this
It
point.
doesn't matter what I have. I'm not breaking any laws. I'm not committing
Listen
any
to me.
crime.
I like guns too. I'm just kind of curious what you like to carry. I'm making small talk. Okay? You can do this bullshit all you want. And I fucking can't stand cocksuckers that do this kind of shit that make it more difficult. I don't have to answer questions. You know what? That's all I hear all goddamn day.
That's not my fault, sir.
It is your fault.
No, it's not.
Because you cocksuckers started. I ask you for ID. When a law enforcement officer asks you for ID, it's not, I don't have to provide it. It's, here it is, sir, because by law, you fucking got to give it when you are asked for it. And if you think you don't press the issue, we'll find out. I'll hook you, book you, jam you into jail. Then you can answer to a goddamn judge.
I've already been through this situation once.
I don't care. You can go through it again.
Okay, so he's got him detained right now, running his background check, waiting for the dispatcher to get back to him. So he's not free to leave while he's being called, sea sucker 2 or 3 times, as well as a sovereign citizen, which there's no evidence in the record that he was a sovereign citizen.
People that I deal with don't have that same thing. Okay? They think just because, I can carry a gun, I can carry a gun. They don't think about the past. All right? I don't know.
By the way, I believe Officer Friendly testified at his deposition that he received no discipline for this at all.
I can check anybody in the world. If I see you have a gun, I can run your name, check you, and see whether you can.
None of the federal judges so far have had any problem with the way the government has treated a citizen here, including calling them a sea sucker.
Where I'm suspect of committing a crime or breaking the law, you are not allowed to stop me.
Okay. Here you go. You're wrong. Take off.
So he gives him his ID back, and now he's free to leave.
Side thing, walk down the road, mind your own business.
Okay. So that's the underlying video. And it seemed like a pretty straightforward case to me from the beginning. There is a Fourth Circuit case that basically says that Officer Friendly is wrong, that the police cannot just see somebody with a gun where guns are legal and open carry is legal and stop and detain them and demand their ID and run their criminal background history to see if they're possibly a convicted felon. You can't do that. There's there's a Fourth Circuit case that's really, to me, directly on point. It says that you can't do that. And the case is United States versus Black from 2013, as I put in the video over and over again. So Judge Gregory, who unfortunately was not on the panel that decided this case when it went up to appeal on the Fourth Circuit, wrote in the Black case in 2013 that being a felon in possession of a firearm is not the default status. More importantly, where a state permits individuals to openly carry firearms, the exercise of this right, without more, cannot justify an investigatory detention. Permitting such a justification would eviscerate Fourth Amendment protections for lawfully armed individuals in those states. Now, what the courts have done here, at the urging of Officer Friendly and his lawyers here, is they take 2 words out of that to completely eviscerate that holding. And those 2 words are without more. So again, let me read that. Judge Gregory wrote, where a state permits individuals to openly carry firearms, the exercise of this right, openly carrying firearms, without more cannot justify an investigatory detention. And that's what took place here, an investigatory detention. So what they've done to get around this case is they took those 2 words without more. And they try to say that, well, United States versus Black doesn't apply here because there's more. Well, let me read a little more in Black. This is again from Judge Gregory's opinion in Black. Here, the individual's lawful display of his lawfully possessed firearm cannot be the justification for his detention. That the officer had never seen anyone in this particular division openly carry a weapon also fails to justify reasonable suspicion. From our understanding of the laws of North Carolina, its laws apply uniformly and without exception in every single division and every part of the state. Thus, the officer's observation is irrational and fails to give rise to a reasonable suspicion. To hold otherwise would be to give the judicial, I've never heard this word before, imprimatur to the dichotomy and the intrusion of constitutional protections. So what they did here is to say, well, there was more than just somebody carrying a firearm, because U.S. versus Black says that just because you're carrying a firearm, if it's legal in that state, that can't be reasonable suspicion. There has to be something more. So what they've tried to say is, well, it's not just any firearm, it's an AR-15, the weapon of choice for mass murderers. And they also turned to a couple other things to try to fill that more, and that is that he was wearing a black cutoff sweatshirt or black cutoff shirt and camo pants. Now imagine if in any of these cases, and it wasn't a white plaintiff, but it was a black plaintiff or Hispanic plaintiff, and the judge said, or one of the lawyers said, well, he was wearing baggy pants, or his underwear was sticking out, or his pants were hanging off of his ass. Imagine if they said that. That would never happen. Absolutely not. But here, it's okay if he's a white guy, because he's probably just an insurrectionist, militia, sovereign citizen type. So you can judge somebody, or police can judge somebody based on what they're wearing if they're white, but they can't judge somebody based on what they're wearing if they're black. There's no way. That would never be allowed. It would never be done. But it's being done in this case because, I would argue, it's not a protected skin color. Just my opinion. But it holds water because he wasn't doing anything illegal. They're trying these legal gymnastics to try to say that there's something more there in the facts when there's not. Undisputedly, he was committing no crime. The question is was it reasonable, or was it objectively reasonable for a police officer to think he was committing a crime, to be able to stop and detain him and get his ID and all that? So what they've tried to say is, well, he had an AR-15 and he kind of looked like a militia guy because of the clothes he was wearing, even though none of that came up in the actual event. And then the other thing they tried to say is, well, there's a school a mile down the road, and had nothing to do with the event. But the lawyers, the defense lawyers, had sort of inserted it into the case after the fact. And all of a sudden now there's a school a mile down the road, if he were to keep walking a mile, well, he could be a mass murderer at his school, because the Parkland shooting had happened a week prior. So undisputedly, no criminal violations had occurred or were occurring or ever did occur. But just because an AR-15 was involved, just because he may have been wearing camo pants, and just because a mile down the road there was a school. And where in West Virginia is there not a school within a mile of any point that you are? There's schools everywhere. That was used here to say, well, we're not overruling black, but there's something more here. Well, isn't that just nonsense? I mean, that is basically saying, I mean, you could go back to black and say the same thing. I mean, if the presence of the firearm, I mean, that's like saying, all right, the presence of the firearm in a high crime area. And that's what they're not allowed to do, according to black, because that means high crime area means a black neighborhood is what they're inferring. So it's not illegal to be in a black neighborhood. It's not illegal to be within a mile of a school. He wasn't near the school. He wasn't within the boundaries of the school. He wasn't in one of these so-called gun-free zones. They took, and they're saying that they can take completely legal activities, completely innocuous facts, and they put them together. They put them together because the officer's so smart, he knows that this could be a copycat shooter heading towards a school. And it's absolute malarkey. It had nothing to do with the underlying case. It's just a bunch of legal gymnastics to try to get around the black case. And that's absolutely wrong. Going back to something that Judge Gregory said, If you look at the Robinson case, another Fourth Circuit case that's bad for guns, 2017, Judge Gregory dissented, and he said, but where a sovereign state has made the judgment that its citizens safely may arm themselves in public, I do not believe we may presume that public gun possession gives rise to a reasonable suspicion of dangerousness, no matter what the neighborhood. And because the rest of the circumstances surrounding this otherwise unremarkable traffic stop did not add appreciably to the reasonable suspicion calculus, I must conclude that the police were without authority to frisk Robinson under Terry's armed and dangerous standard. So here we have a Fourth Circuit panel saying that, well, public gun possession does give rise to a reasonable suspicion of dangerousness if it's an AR-15 and if there's a school a mile down the road. Now, if they allow that in the Walker case, they have to allow that in the Black case. Well, what is reasonable suspicion? Reasonable suspicion is what police officers need to detain you, to go from beyond just talking to you in a consensual encounter to actually detaining you against your will. That could be a traffic stop where you're not free to leave until the traffic stop's over, or it could be with a pedestrian like what Michael encountered, where a police officer stops you and IDs you and requires you to give you his ID and then runs your criminal background with the dispatcher. So they can't just do it based on a hunch or on, they're not supposed to be able to do it just judging you on what you look like. It's supposed to be a reasonable belief. And what it is a common sense, non-technical standard that relies on the judgment of experienced law enforcement officers, not legal technicians. So a detaining officer has to either articulate why a particular behavior is suspicious or logically demonstrate, given the surrounding circumstances, that the behavior is likely to be indicative of some more sinister activity than may appear at first glance. The important thing here in determining whether there's reasonable suspicion, just like determining whether there's probable cause, is that it has to be particular to the individual. It has to be particularized. It can't be generalized. It can't be categorical. And what exactly did the Fourth Circuit just do here in this case? And I haven't really gone through it yet, but that's exactly what they did, is they decided the case on generalities, not on Michael himself specifically. They made generalizations about AR-15s. They made generalizations about camouflage pants, believe it or not. There was no behavior by Michael Walker. There was nothing dangerous that he was doing. There was nothing suspicious that he was doing. It was all categorical generalizations. And that's exactly what all the cases say that you're not allowed to do, that you're not supposed to do. So it has to be particularized suspicion of illegal conduct. And we get into a little bit of gray area here where some cases say that you can have this amalgamation of legal conduct that together can equal suspicion of criminal conduct under some circumstances. But I would argue, as I have in this case, that it still has to be things that when you combine them, potentially creates its suspicion that a crime is being committed based on the particular facts. So yeah, somebody could have a baseball bat, which is legal to possess and own. But if you take that baseball bat and stand next to somebody at an ATM or something like that and start mugging, mean mugging them anyways and intimidating them, now, yeah, technically maybe you're allowed to have that baseball bat there, but there's particularized information that this person may be engaged in a crime. Here, you just literally have somebody walking down the side of the road, doing what they're allowed to do in a state in which they're allowed to do it. There was no particular information that was particular to Michael Walker in this case. It was all categorical and generalized irrational suspicions. So it's also supposed to be judged on an objective standard. So it's not whether Officer Friendly, who clearly doesn't understand the law, it's not whether he made a mistake of the law or what he specifically thought. It's what the objective, reasonable police officer would think. So that's another place that they've gotten sideways in their legal gymnastics here, is they concentrate on the fact that there was this Parkland shooting and these other shootings, and Officer Friendly, Mr. Donahoe, he had it in the back of his mind that he was afraid that this could be a copycat. There's no facts in the record that had anything to do with Michael potentially being a mass murderer. Nothing in the record at all. And in fact, as I pointed out in some of the briefing in the case, Cruz, who showed up, who was the Parkland shooter, showed up not by walking down the side of the road openly carrying an AR-15. Yeah, he had an AR-15 style rifle, but he arrived in an Uber and he had it broken down into a black duffel bag. There was no facts in common between Michael Walker and Nicholas Cruz. Now, there's also just looking at this since they've issued their decision, there's also a U.S. Supreme Court case from 2000, Florida versus JL, where the U.S. Supreme Court was asked to recognize a firearm exception to the requirements to justify a Terry search. And the Supreme Court refused. And they said they declined to recognize a firearm exception justifying a Terry search in a case that's dealing with an anonymous tip alleging that an illegal gun would be found on the target of an anonymous tip. The court's reasoning was grounded upon the reliability inquiries attending anonymous tips rather than the issue of whether mere possession of a firearm alone can establish a per se basis for an investigative detention. Now, so that's the Supreme Court has said, even if an anonymous caller, and we did have an anonymous caller in this case, even if an anonymous caller calls the police and says, look, here's a tip. This individual is going to have a firearm on them or an illegal firearm on them. That was not enough. The court is not going to create a firearm exception where officers can say, well, if the person's armed, then we get to stop and detain them and do a Terry search and get their ID and all that. So the Supreme Court has already nixed that idea. Let's see. So you may have, I do have a video of when we had oral arguments on this case, and I'll post a link to that, but I'll show you just a little bit of that. So these are the actual oral arguments when it went to the Fourth Circuit. And of course, it was being done over Zoom, unfortunately.
The district court opined here that the open carry of an AR-15 in West Virginia is a, quote, developing area of the law as courts face the expansion of open carry, end quote. But to the contrary, the legality of open carry in West Virginia is nothing new. It's not on the table at all. It cannot be disputed. United States versus Black was issued by this court 7 years ago. And the right to exercise the open carry of firearms has long been the law of West Virginia. In fact, the right to keep and bear arms for self-defense, hunting, and recreational use in West Virginia is expressly set forth in our West Virginia Constitution, in Article 3, Section 22. In this case, Michael Walker was stopped, subjected to a detainment, including a background check. It's called vulgar, obscene, and offensive names, all without having committed or even being suspected of committing criminal activity at all. He was just walking. The fact that he had a legal to possess rifle safely and non-threateningly strapped over his shoulder without more can't.
Now, if you watch the rest of those oral arguments, they quickly sort of go sideways when the judge who was the author of the opinion started comparing the AR-15 to the M16. So I had a feeling that the opinion wasn't going to go very well. Before I get more into the opinion, it was a fairly recent from 2020 Fourth Circuit case, USA versus Curry, which I'll point out that also doesn't jive with what they've done here today. Let me see if I can bring this up on the screen. And I just noticed that I'm using my other camera here, which is supposed to be better and in 4K, but it automatically adjusts for low light. And as it's in my Lewisburg office, it's full of windows. And as the light is going down, it's adjusting. And I'm not sure how it's an adjustment because it just gets worse. Anyways, here's a little part that I highlighted from the case of USA versus Curry. Again, a 2020 case from the Fourth Circuit. And if you just Google it, USA versus Curry, you can find it. I'm sure I've posted it before on my website. But this is the opinion where the Fourth Circuit is describing why these police officers in that case were bad. Again, this was involving a black guy in Richmond, not involving a white guy walking down the side of the road. So we had a little bit different analysis there. A few final points bear mentioning here. First, our ruling today will not hinder the police's ability to forcefully respond to emergencies. And well, let me give some background here. What happened is basically you had some 911 calls and you had all these gunshots happening near an apartment complex in Richmond. I guess it was sort of like a public housing type of deal. So they described it as an active shooter situation. I mean, there's gunshots going. The police get there, they're actually pretty close by. They get there and they see a bunch of black guys like walking away from the scene. They look kind of suspicious. One appears to have been like shot in the arm. He's like clutching his arm. I don't recall, maybe he was even bleeding, but these cops went and stopped them and ended up finding a gun on one of them, and litigation ensued. And the court had found, to make a long story short, that it was an illegal stop. It was an illegal detention because, there wasn't reasonable suspicion, really the same issue that we're dealing with here. So let's contrast this holding with what they've done now in the Walker case. So in the court's giving the background here, and we need not define an active shooter situation to conclude that the situation faced by officers in this case, as described by the district court and blah, 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 was not one. So they're basically admitting that this was this super serious, it was a real active shooter situation, not one made up in the back of a police officer's mind. The officers here relied on the sound of 5 to 6 gunshots in the distance near an apartment complex, corroborated by 2 911 calls and the sight of several men separately and calmly walking in a public area nearby less than a minute later, including an apparent victim who seemed to be favoring one of his arms. Second, we note that in attempting to frame the situation as an emergency that allowed police to stop and frisk Curry. Now, mind you, the Parkland shooting happened a week before approximately the Walker stop. And that's being used to basically suspend the Constitution and allow Officer Friendly to stop my client because there was a mass shooting a week before. Here, there's actually a mass shooting happening at the time that this happens, and they're still found to be unconstitutional. All right, back to the holding here. The government makes much of the fact that there were several shootings in the Creighton Court area in the weeks leading up to the incident in question. Although this fact is certainly relevant to our analysis, it did not provide the officers with this type of specific information that would be necessary to justify a suspicionless seizure, even when combined with other pertinent facts. Wow. So, moreover, for the same reason, a person's presence in a high crime area cannot alone create a reasonable suspicion to justify a Terry stop. We refuse to give this fact any special weight in determining whether the officers faced exigent circumstances. To do so would deem residents of Creighton Court or any other high crime area less worthy of Fourth Amendment protection by making them more susceptible to search and seizure by virtue of where they live. Such an approach risks treating members of our communities as second-class citizens. Now, what are the differences here between the Walker case and this Curry case? Well, in the Walker case, being within a mile approximately of a school creates a kind of a fourth dimension of diminished Fourth Amendment protections because, you know, for the kids, for the safety of the kids, they could be in danger. You know, if you're within a mile of a school or walking in that direction, you could be a potential mass murderer. You could be a mass murderer. But if you're in a high crime area in downtown Richmond, that cannot be used against you. And there could even be an active shooting going on in that high crime area, gunshots ringing out. That can't be used against you. The location of being in this high crime area can't be used against you. But that's a black area. If you're in a white area of Putnam County, West Virginia, heck, if you're even within a mile of a school, boom, cops can stop you if you're armed and they can get your ID because, there's kids a mile down the road. So there's nothing racially discriminatory about that at all, is there? So if you're in a black high crime area, the court is really going to hold the police officers to the standard of giving particularized information, really information about what these individuals or this individual did that's suspicious of a crime having been committed or being committed, or to suspect that they were actually involved in that shooting. Heck, even though one of them's been shot in the arm, it appears, the cops aren't allowed to do that in Richmond. However, in Putnam County, West Virginia, just with an anonymous Karen call, which the Supreme Court has said is not reliable, they can stop you, they can run your ID, they can call you a sea-sucker 3 times. And, it's completely allowable. So again, that is another Fourth Circuit case here from last year, USA versus Curry. So it really is, and this is what I'm going to do is I'm going to petition the Fourth Circuit to rehear this case en banc, which means with the entire court sitting, because the decision that they handed out today flies in the face of all this stuff. What's the only thing that's different? It really appears the only thing that's different is skin color. I mean, it shouldn't have anything to do with it. Now, that had nothing to do with the underlying stop here. But what I'm pointing out here is we have 2 different legal standards. It had nothing to do with the stop, but it has to do with the litigation afterwards, because Michael Walker did not have the same protections as this Curry guy. Michael Walker did not have the same protections as Mr. Black. And that's just the way it is. And that's unfortunate. And I'm going to point that out to the court and see if they'll take this up. Because if they're going to create this diminished Fourth Amendment status for Michael Walker in Putnam County, West Virginia, then they have to apply that diminished status, and it will be applied all throughout the Fourth Circuit, which is not just West Virginia, but Virginia and Maryland and North Carolina, South Carolina. Now, I'll bring up the opinion itself here. All right, I've talked a lot about it, but I haven't really quoted but that one little part of it. So you can find it on the website at thecivilrightslawyer.com. I've published it in full, but it is a published opinion from the Fourth Circuit, so you can find it published in all the places you find the published court opinions, including on the Fourth Circuit's website. So this is the case, just came out this morning. All right, so February 14th, 2018, that's back when this happened. A week before, and this is how they have to start it off. A week before Walker was stopped and detained, a 19-year-old gunman in Parkland, Florida, opened fire inside Marjorie Stoneman Douglas High School with an AR-15 style assault rifle. Parkland school shooting claimed the lives of 17 persons and wounded several others. That massacre received extensive national news coverage, one of the deadliest school shootings in American history. The Parkland shooting serves as background for the events giving rise to this 1983 action. Also pertinent is that it's generally legal in West Virginia. Not generally, it is legal in West Virginia to openly carry firearms, including AR-15 and other semi-automatic assault rifles. Nevertheless, eligibility to possess and carry firearms is subject to some limitations. For example, they make a big point out of this. Someone can be under the age of 18 years old. Now, you saw Michael in the video. He doesn't appear to be under the age of 18. They never suspected him of being under the age of 18. That's just something that's part of the legal gymnastics that came out after the fact to say, well, how can we get around the Black holding? How can we find any other constitutional way to justify this stop? The fact is that he committed no crime. No one said he committed a crime. The 911 caller did not accuse him of committing a crime. The police officers, I took their depositions under oath. They testified that they did not observe Michael committing any crime, that they didn't observe him acting dangerously or anything like that. There was no crime at all, yet the courts have allowed a Fourth Amendment seizure to have taken place based on completely innocent and legal activity. Why? Because it was an AR-15. Well, because it was a firearm, but specifically because it was an AR-15. Now, who made that decision? Was it the West Virginia legislature? Nope. This is judicial activism. This has been made by the judiciary. They were asked to do it by the Putnam County Sheriff's Department, specifically Officer Friendly here. So the law says that you can't just see somebody with a gun and assume that they might be a felon. After all, that might be judging somebody on their skin color or the neighborhood that they live in, something like that, which you can't do. So that's the law. We accepted that, but they're going to make an exception here for the AR-15. There's no basis in the law for it, but that's basically what they did. And so they go through all the background, and some of it is not completely accurate, but it is what it is. There's no facts again showing that he had committed any crime, period. I mean, there's just not. So skipping to the law, let's see. All right, so they really bend over backwards to try to say that Black doesn't apply. So in our Black decision in 2013, we were called upon to determine whether reasonable suspicion supported the investigatory detention of Mr. Black in that case, who was convicted for being a felon in possession of a firearm after he was searched at the scene and they found a gun. So Mr. Black had been carrying the concealed firearm while among a group of 6 men who were stopped, questioned, and frisked by police officers in Charlotte, North Carolina. Okay, he sought to suppress the evidence of the firearm that was found during the investigatory detention. The government identified several circumstances that arguably endangered reasonable suspicion to support the investigatory detention, including that one of the other men in Black's group, Mr. Troop, was openly carrying a handgun. And again, in North Carolina, the open carry of a handgun is absolutely legal. So he had and they're okay. This is how they substantiate this. He had a firearm and a holster on his hip in plain view. Now it was a handgun. So they think the handgun's okay to open carry. Now, this is, again, not the legislature. This is a federal court of appeals determining that the West Virginia, by God, legislature, they should not allow the open carry of AR-15s. All right. So the government in the Black case, the government put forward the theory that this guy in possession of a firearm was a circumstance that created reasonable suspicion to stop and detain them. All right. In so doing, we refuse to find reasonable suspicion merely by association. So again, it's supposed to be particularized, right? Individualized information, not generalizations. So we concluded that Troop's firearm was an insufficient basis to stop and detain Troop himself. Well, why is that not an insufficient basis for Officer Friendly to have stopped and detained Michael in this case. In that regard, we emphasize that it was undisputed under the laws of North Carolina, which permits its residents to openly carry firearms, that he was legally possessed and displaying the firearm. Again, same thing we have in Michael's case. It's undisputed. He was legally possessed and displaying the firearm. In that case, the officer's ignorance, their lack of knowledge as to whether it was legal for him to be in possession of the gun, did not warrant him to run a criminal history check. Well, how's that different than what happened to Michael? Obviously, Officer Friendly, Corporal Donahoe, he had no idea what the hell he was talking about. He thought he could stop and ID anyone. He thought West Virginia was a stop and ID state, which it's not. He thought if he saw anybody with a firearm, and he didn't have to have any kind of other reasonable suspicion. He didn't have to think that they may have been a school shooter or may have been under 18. He just thought that they might as well be, if you have a gun, he's going to stop you and get your ID and see if you might be a felon. That is what his testimony was. But here, they said, well, hey, whether this officer, his lack of knowledge as to whether Mr. Troop was lawfully allowed to possess the gun, did not warrant him to stop him and run his criminal history, because being a felon in possession of a firearm is not the default status. Where the state permits individuals to openly carry firearms, the exercise of that right without more cannot justify an investigatory detention. Permitting such a justification, we explained, would eviscerate Fourth Amendment protection for lawfully armed individuals in those states. All right, so Michael was a lawfully armed individual in one of those states, in West Virginia. So they're permitting the justification of a police officer in his lack of knowledge about whether it was legal to stop and run his criminal history. Because being a felon in possession of a firearm is not the default status. So Michael's case is exactly what happened, pretty much as close as you're going to get to what happened in the U.S. versus Black case. But yet Michael did not get the protection of that law. Why? Well, he wasn't in a high crime area. And I don't know what else, how else could they justify it? Has there been a change in the law just because there was a shooting in Parkland? No. The judiciary does not change laws. The legislatures do. All right. Now, they continue with comparing this to Black. As for whether there was something more, remember we talked about without more. Well, was there something more about Troop's possession of a firearm to justify what happened to him? We concluded that there was not. We ruled out that it was insufficient that Troop was the first person an officer had seen openly carrying a firearm in that police division of Charlotte. Well, we have the same thing here. Officer Friendly, he ignorantly thought that if he saw somebody openly carrying, he was justified in performing an investigative detention. He was wrong. We separately dismissed as insufficient circumstances related directly to Black, including that Black at first seemed overly cooperative, that he volunteered his identification papers to the officer, and that he lived outside the division. Consequently, we determined that the evidence of Black's firearm must be suppressed and his conviction vacated. So also in the Black case, what else did the officers know? They thought he was suspicious because not only was there a gun, but Black was acting, in their experience, overly cooperative, which was suspicious, and that he too quickly volunteered his ID to the officers. It was just suspicious, and he lived outside that area. So all of those things combined, that still wasn't enough. We didn't even have that here in the Walker case. We didn't have any evidence that Michael had done anything suspicious at all, other than be in possession of a firearm. Or in other words, be a lawfully armed individual in a state that allows it, just like the holding in Black. But somehow they're doing this. Somehow I don't know. Somehow they're saying, all right, this is the law, but we're going to do something different, even though we're compelled, we're bound by stare decisis to follow our earlier precedent. We're just not going to do it because we're just going to pretend it's different facts. So we turn to Walker's argument that our Black decision compels the conclusion that Donahoe's investigatory detention of Walker contravened the Fourth Amendment. All right. So according to Walker, it's according to me, Black holds that the lawful possession of a firearm and use in West Virginia cannot form the basis of reasonable suspicion to perform a stop in investigatory detention. Well, that is what Black holds. Walker further contends that there's no lawful basis to treat an AR-15 style rifle with any less measure of protection under the holding of Black as is granted to any other lawful firearm under state law. Well, Black did say, where is it? All right. Where a state permits individual to openly carry firearms. It didn't say just pistols. The exercise of this right without more cannot justify investigatory detention. It doesn't say. It doesn't limit it to just pistols. In fact, what was the language? Well, the language was basically that to do so would infringe on the rights of citizens to lawfully, exercise their rights to possess and carry firearms in West Virginia or North Carolina. And that's exactly what they're doing here. This is their argument. Contrary to Walker's interpretation, the Black decision does not dictate that in a state like West Virginia, where it's legal to openly carry a firearm, the act of openly carrying a firearm can never engender reasonable suspicion. Indeed, Black explicitly allows that the possession of a firearm, though lawful, can contribute to reasonable suspicion in the totality of the circumstances. That is, the possession of a firearm plus something more may justify an investigatory detention. All right, so again, that's how they're doing this. They're saying, all right, there was something more here. The notion that lawful conduct can contribute to reasonable suspicion. All right, see, they use the word contribute. No, not contribute. They're forming reasonable suspicion with lawful conduct. That's completely different. The Black decision itself cautions against the misuse of innocent facts as indicia of suspicious activity, but acknowledges that factors susceptible of innocent explanation, when taken together, may form a particularized and objective basis for reasonable suspicion. And this is a laugh. In his appellate brief, Corporal Donahoe helpfully points to cases in which the possession of a baseball bat and a golf club, when viewed in the context of all the circumstances, justified an investigatory detention. There's a Ninth Circuit case, all right? That's even before Black was decided. And then you had a Sixth Circuit case, United States versus Ivy. So, and the Degier case in the Ninth Circuit, the backseat passenger was holding an object that could be used as a weapon, a baseball bat. All right, backseat passenger, what does that mean? Traffic stop, there already was reasonable suspicion. That's not even a reasonable suspicion case. Maybe I'm wrong about that case, but it doesn't matter anyways. All right, the other case, United States versus Ivy. Ivy was loitering in a gas station parking lot with a golf club. All right. Mattered not that baseball bats and golf club, and that's a Sixth Circuit case. Mattered not that baseball bats and golf clubs, like firearms in West Virginia, have a multitude of innocent uses. All right, how much do you want to bet the Ivy case, which is not binding in the Fourth Circuit, had more facts than just the guy had a golf club? All right, so you have a golf club in a parking lot. I'm willing to bet that there was all sorts of facts about why this was suspicious. Who the officer might have known who the guy was, how he was acting, observed him, things like that. There was a potential suspected crime, or maybe not. Maybe that ruling was BS too. I don't know. But you know what? It's offensive to compare our Second Amendment rights to golf clubs, frankly. All right, skipping down some. Walker is also incorrect in reading. This is really where it gets awful. So I'm incorrect, basically, in reading the Black decision to prohibit consideration of the type of firearm at issue. So, in other words, they're allowed to discriminate against the AR-15. Black was a handgun and a hip holster. Okay, so here they're going to attack the AR-15. So the proposition that an AR-15 style assault rifle may be treated differently than a handgun is consistent, not only with Black, which it's not. It's not consistent with Black at all, but also with the Supreme Court's decision in Heller. And this court's subsequent decision in Colby versus Hogan, which is an awful, awful decision, Fourth Circuit en banc 2017. That was the Maryland assault weapons case. And so now they're going to start to apply Maryland law to West Virginia. You should be like these tyrants in Maryland, and your legislature just doesn't know any better. In Heller in 2008, the Supreme Court determined that the Second Amendment guarantees individual right to possess and carry weapons in case of confrontation. The court emphasized, however, that the right secured by the Second Amendment is not unlimited. It extends only to certain types of weapons. Awful part of that decision that they keep using against us over and over and over again. The court easily concluded that the District of Columbia's prohibition against the possession of handguns in the home was unconstitutional, as handguns are the most preferred firearm in the nation to keep and use for protection of one's home and family. But the court concomitantly specified that weapons that are the most useful in military service, M16 rifles and the like, may be banned without infringement upon the Second Amendment right. Now, what's the difference here? That's when they were looking at the assault weapons ban in Maryland. This is the Fourth Circuit, awful decision. So they're reviewing the assault weapons ban in Maryland, where the legislature did make these findings and did enact a ban. What are we missing in the Walker case? Well, West Virginia's legislature is not a commie legislature like they have in Maryland, and they haven't banned so-called assault rifles. So it has nothing to do with us. Moreover, there's no evidence in this case or otherwise that the AR-15 has anything to do with an M16 rifle, which is a machine gun, fully automatic. And the AR-15 is not. Thereafter, in Colby in 2017, we considered the constitutionality of the state of Maryland's ban on AR-15 and other semi-automatic assault rifles. Applying Heller, this is the Colby decision here. Applying Heller, we formulated the dispositive question as follows. Are the banned assault weapons like M16 rifles, i.e. weapons that are most useful in military service, and thus outside the ambit of the Second Amendment? Based on the evidence before us, we observed that banned assault rifles have military combat features, according a capability of lethality, more wounds, more serious, and more victims, far beyond that of other firearms in general, including other semi-automatic guns. All right, so that is a finding of these courts in the context of whether the Second Amendment protects, whether the Second Amendment prevents a state legislature or the DC, well, whatever their legislature is called, from banning AR-15s or other firearms. That's the context and where the government is saying, look, these military style or these firearms with military features are dangerous. We have this government interest in protecting our citizens from these type of guns being around. And so the question is whether the legislature can do that, or whether we have a Second Amendment right to possess these guns, even where the legislature tries to take them away. That's the context. So now the Fourth Circuit is taking that, which are bad law anyways. They're taking that, and now they're using it in West Virginia, where it has nothing to do with West Virginia. Our legislature has not done that. We're allowed to own as many AR-15s as we want. We're allowed to strap them on our shoulder and walk down the side of the road. But the judiciary doesn't like that. They think that, all right, because in Maryland, we found that these evil black guns are so scary and they're so bad that police officers in West Virginia, even though they're completely illegal, they can stop and detain and run criminal history on people that they see holding them. And because black didn't specifically mention AR-15s, then they think that it doesn't violate black. So I disagree. Our examination of the record leads us to agree with the district court that Donahoe had reasonable suspicion that Walker was intent on perpetrating a mass shooting at Tays Valley Christian School. They pulled that out of nowhere. There's no evidence in the record that he had committed any crime or that he was observed doing anything wrong other than being in the possession of an AR-15 style rifle. He, according to the testimony, was holding it in a safe manner. He wasn't acting in a threatening manner against anybody. He wasn't doing anything that was illegal or threatening to the safety of any individual. But yet the courts concluded that it was a reasonable suspicion that this police officer could think that he was intent on perpetrating a mass shooting at a school that was a mile away. I mean, that is absolutely absurd. Imagine inserting that sort of logic into one of these other cases where you have a black man in a high crime neighborhood in Richmond or in Charlotte. So you could find it reasonable that an officer thought that all right, well, there's a school down the road, or let's say there's a gas station down the road. Now the officer thought that, well, he might go rob that gas station because he had a gun, because most people that rob gas stations use guns, and lots of people have been killed in gas station robberies, and it's a high crime area. That gas station may have been robbed 50 times before, and that officer knows about it. No, they're not allowed to do that. But here they're allowed to do it because it's in a different area and a different type of guy that's involved. Another lawyer I know pointed out this comparison. This is like saying that anybody with, I know we're not allowed to assume genders anymore, but anybody with a male body part, say, is walking in the direction of a female or a group of females. That's like saying that a police officer could stop and detain that person and run their criminal history and so on because they have that male body part. And that's what's used to rape women. And it's happened many times. You can list all sorts of events. That is the same exact logic here. He was walking where he was allowed to be, holding what he was allowed to hold, that he was lawfully armed. There's no facts to show that he was doing anything wrong. Yet that's the same exact thing that they're doing here. And why are they doing it? Just because it's the AR-15. So it's inserting politics. It's inserting judicial activism into the case law here. And it's just not right. The only other thing really they came out with is his appearance. Let's see. Where is it? Somewhere here they mentioned what he was wearing. All right. Walker was dressed to look like a soldier in a black sleeveless shirt and camouflage pants. Now, that was nowhere in the facts of this case. You can see what he's wearing in the video. That had nothing to do with it. And the word military, wasn't mentioned. All right. So they cite this Sixth Circuit case from 2012, concluding that military style clothing contributed to reasonable suspicion justifying an investigatory detention of plaintiff while he was open carrying a firearm. Okay. Military style clothing. All right. Dressed to look like a soldier. That was not in the evidence anywhere. Wasn't said. It had nothing to do with it. Black sleeveless shirt and camouflage pants. That first came from the trial judge, his ruling, but it had nothing to do with it. And I suppose that judges can look at the video and take judicial notice of what someone appears to be wearing. But again, imagine that happened in a different scenario with Mr. Black in downtown Charlotte or Mr. Curry in downtown Richmond. And then once you look at it and through that sort of a situation, then that might not be such a good idea. In this day and age, are we really going to give the police officers the leeway to make these sorts of decisions? to make generalizations like, all right, well, I think he might go commit this crime because he's in possession of some legal object which could be used to commit a crime. Because based on my experience, blah, blah, blah. No, we need to restrict the government's authority to do things such as that. And it shouldn't be based on, the law should equally apply to Michael Walker in Putnam County, West Virginia, as to Mr. Curry in Richmond, Virginia. Let's see, what else did they say here? All right, so you can thank good old Corporal Donahoe here. As Corporal Donahoe emphasizes, AR-15s have been the weapon of choice for the deadliest mass shooters of the past decade. Let's see, or did I already read that? Yeah, I already read that one. Second, the Parkland school shooting occurred just a week before Walker was stopped and detained while carrying an AR-15 style rifle. As would be expected, Corporal Donahoe said that he'd been on heightened alert for possible copycat crimes. And significantly, the Parkland shooter used an AR-15 style assault rifle to kill and injure his victims. Okay, again, in reality, he didn't openly carry that. He brought it in a duffel bag via Uber. Okay, and so they're going to allow Corporal Donahoe to have this thought in the back of his mind that, well, I'm on heightened alert because of the shooting that happened in the past, and therefore, even though he hasn't done anything wrong, I'm going to stop him. I'm going to get my ID, and it's justified because I have this thought in the back of my mind. Well, that's the same thing as that's what they did not allow the officer to do in the Curry case or in the Black case. So they weren't allowed to have the thought in their mind that this guy might be a criminal because he has a gun, because it's a high crime area, or whatever else. They didn't even allow him to do it, even though there was specific facts about he was acting suspicious because he gave his ID over too quickly, blah, blah, blah. No, this guy, Donahoe, can do anything. He can even call him a sea sucker, and it's not mentioned. Walker was walking towards and within a mile of Taze Valley Christian School, although Walker, i.e. me, argues that location is an improper consideration under our Black decision. Black did not so hold. Rather, Black ruled that no reasonable suspicion arose from the mere fact that a handgun was being openly carried in a location where an officer had not seen that done before. And Black did not say handgun. It said firearms. It said lawful firearms. Moreover, the Supreme Court has recognized that officers are not required to ignore the relevant characteristics of a location in determining whether the circumstances are sufficiently suspicious to warrant further investigation. Okay, so you get the idea here. The fact of the matter is that none of that had anything to do with the underlying case. The officer, if you watch the video, he didn't even mention the school that was a mile down the road. He didn't mention any suspicion that he could be a school shooter. In fact, after he let him go, he didn't even follow him to see where he was going. He was still walking in the direction of the school. He didn't follow him to see if he was going to the school. I mean, supposedly he was looking out for the kids. If he really was a school shooter, it still would have happened because Donahoe went the other direction, and he didn't ask anyone else to go see where Michael was going. Obviously, he wasn't a school shooter. And the other thing that kind of we found out a little too late is that we found the fact that it was actually 6 o'clock in the evening when it took place. 6 o'clock in the evening, and therefore the school wasn't even in session. And so he had testified that school was in session during his deposition, but school wasn't in session. It was 6 o'clock in the evening. And in fact, I didn't realize it at the time, but you can hear the crickets chirping. And I researched that, and apparently there's a scientific consensus that the crickets only chirp in the evening, not in the morning. So school wasn't in session. It was all BS, and the courts have allowed it. So here's what we're going to do is we're going to appeal it to the Fourth Circuit en banc, and hopefully maybe at least Judge Gregory, who was the author of Black, will fight for this to be heard again. And maybe we get a better opinion. And if not, then I've already talked to some other lawyers, and I'm seriously considering appealing to the United States Supreme Court if we can't get this heard again en banc. So it's still not over. We're still fighting this fight, but it's crazy that you have something that is so simple, the fact pattern that fit exactly within what happened in United States versus Black, that was treated differently here. And I only asked the question, what is different about this case? There's no individualized information pertaining to Michael that he had committed any crime, that he was observed doing anything suspicious of criminal conduct. Nothing. He was where he was allowed to be, going where he was allowed to go. He acted completely appropriately, and he was treated like human garbage by this police officer. He was called a sea sucker 2 or 3 times. He was called a sovereign citizen, which he wasn't. And this didn't make its way into the case, but they actually put a bolo out on their little intelligence information across the state, calling and identifying Michael as a sovereign citizen. And when I deposed this officer, he claimed that he didn't do it. So whether he did it or not, I don't know. He says he didn't, but I don't know who else would have inserted that information into the intelligence gathering exchange, identifying him as a sovereign citizen. And I know the reason, because next time when they stop him, they can say, oh yeah, well, he came up as a potential sovereign citizen, as a dangerous guy, could consider it armed and dangerous. That's why they did it, for the next stop. They would pepper his Angus at the next stop. That's what that was about. But fortunately, once I got involved, far to my knowledge, they never did mess with him again. But it's just a shame that such what should have been a piece of cake case, directly on point that it's unconstitutional, has had to have been litigated and has been lost all the way to this point. And not even lost on qualified immunity grounds, but lost on the claim that it wasn't unconstitutional. And it's just clearly wrong. And because if it's not unconstitutional to seize an individual for doing something that they're allowed to do, then we have a problem here. Yeah, you could have things that are legal to possess, like golf clubs, that could partially form the basis of reasonable suspicion, but you got to add facts. Those facts are not here. There's no facts that he was acting suspiciously. He wasn't standing in a parking lot loitering outside. He wasn't standing next to an ATM. He wasn't going into a bank. He wasn't going into a school. He was doing nothing suspicious other than being in possession of an AR-15. And that's what they don't like. That's what they've attacked here. So I appreciate you watching. If you've made it through this whole thing, I think the reasonable suspicion area of cases are really the most dangerous type of cases, because even though it's supposed to be an objective standard, they're using a subjective analysis and not admitting it. And this is how the government really whittles away our rights. It all started with the Terry case and the Warren court. And it's just gotten worse and worse and worse and worse with the whole line of Terry cases. And that's basically what we have here. So the fight continues. Again, this is a Fourth Circuit case. If you don't quite understand, this applies. This is now a published opinion in the Fourth Circuit. So that's West Virginia, North Carolina, South Carolina, Maryland. So it doesn't, it's not binding legal precedent in any other state right now. And in fact, if you're in the Sixth Circuit, there's cases that are actually directly contrary to this holding. But anyways, thanks for watching. And it's good that this at least got me spurred to get back on track doing live videos, because I've just been having too much fun this summer. And too many other things going back on, but the tyrants are not resting. They have not rested. The government's threatening to go door to door at this point. So there's a lot of work to do. There's going to be a lot more work to be done. So, please make sure you subscribe to YouTube if you haven't, and click the little bell or whatever it is so that you get notified. I'm sure I'm still shadow banned to some extent, but subscribe anyways. And also you can subscribe on Facebook, and also check out the website, thecivilrightslawyer.com. Thanks for watching, and I'll see you next time.